Good evening, Crime Talk aficionados. My name is Scott Reich. This is Crime Talk. It's Tuesday night after... Oh, hold on. We got a little sound issue. Anyway, it's on... Hold on. All right. I think we're good now. All right. Good evening, Crime Talk aficionados. My name is Scott Reich. This is Crime Talk. This is our Tuesday night live show, which is affectionately known as After Dark, because, well, normally it's After Dark, but now that daylight savings come, it's really not that after dark. But anyway, you get the gist, you get the idea. First of all, thank you for joining us. For those of you who maybe are joining us for the first time or not sure, hey, is it worth watching this guy? What does he have anything to say? Well, I have been practicing criminal defense work for 27 years, so I think I have a pretty good idea of what is going on. And obviously the big topic of the day, so to speak, is the order denying the motion for severance that was filed by John Pryor on behalf of his client, Chad Daybell. Now, yeah, he lost, but he really didn't lose. So we'll get to that. In fact, frankly, I think he won on the most important issue that even the judge recognized. So we'll talk about that. And we didn't do a show today because it was kind of a weird, crazy day. And for those of you who noticed yesterday, I was on the road. Yesterday was a very long day. I left my house at 6 a.m. in the morning, drove to the airport, caught a commercial flight. I know, commercial. Then I flew to Houston, conducted a proffer, a meeting, whatever you want to call it, and then flew back home same day and got back to my front doorstep that I left at 6 a.m. that morning at 11 p.m., which isn't bad. I mean, it's not the worst day. It was just the waiting part. There were weather delays down there in Houston because I guess they had some tornadoes and all this other stuff. We took off. We had to fly around it, which I get it. Hey, better to be safe than sorry, but it makes for a long day. I remember getting out of the car. I was like, oh, my gosh, I'm so sore. I've been sitting all day. So it just sucks when you get kind of stiff like that. But anyway, today was a good day because I had a day in the office, which was always kind of nice. And Julie put a picture up of me reviewing the order in the Chad Daybell matter there, making some notes here on the side. And somebody said, Scott, you have jeans on. Yes, I do. I didn't have any court. Didn't have to go to court, so that's always a good sign. And pre-COVID, I would have always been wearing a suit, but I have become much more accustomed saying, if I'm not going to court, why am I wearing a suit? Still try to look professional. Always try to wear a sport coat at the minimum. But yes, I do have on jeans today. So I think it was Mama Pink that noticed that. But yes, we have jeans on. All right. So did a quick intro. You know who I am. That's pretty much it. I've been doing criminal defense for a long time, and I think we normally get it right. Every now and then we miss it, but things usually turn out the way they're supposed to, or at least the way I think they're going to turn out. And this one pretty much turned out the way I thought it would as well. We'll talk about that. Now, if you haven't, told your friends about Crime Talk, would you please do so? Share it, share the video, let them know so that we can grow. Our numbers are doing well, but I'd like them to be better. Okay, really would like them to get up there. So please share, like, subscribe if you haven't already done so. And I think this one we'll put up on the podcast as well tomorrow. But you can always listen to us or any of our previous shows that we have put up. So let's do an update on a couple of the stories that we brought you the other day. And now I think probably most people have seen the guy jumping the Tesla. He was our dumb criminal yesterday. And I think he's been identified, but he hasn't really come forward and not claiming responsibility. Police haven't identified him. You would think the car was a rental. They would know who they rented the car to, but you never know. Frank, do we have that video for those who haven't seen it? Here it goes. So the Tesla is at the bottom of this hill, apparently in San Francisco. He comes flying up the hill, and boom, Goes airborne. Boom. All right. That jump is epic. That jump is epic. Who hasn't thought about that at least one time in their life? Wouldn't that be fun to do some like Starsky and Hutch jump? Well, this guy did it. But, one of the reasons why I became a dumb criminal is one, you don't live stream the crime scene, which is basically what he did. So now there's witnesses, there's people there. The guy will ultimately be identified. The police were still looking for him. The guy who jumped it, there's a couple people kind of on YouTube kind of taking responsibility for it. But another reason why the guy was our dumb criminal is because you noticed he hit several cars at the end of the street. Well, he obviously didn't stick around to report anything and provide his insurance number. So the people that have had their cars damaged that night, they want everybody. The guy that got one of the individuals with his car damaged that night was a guy by the name of Jordan Hook. And he is a little upset because, well, his car is now busted. And, that affects people's lives when their property gets destroyed. I mean, how many times have I said that? Don't take other people's things. Don't damage other people's things, because it may not be a big deal to you, but it's a big deal to those people. I wonder if this guy was even wearing a helmet when he jumped, but I don't know. I'm thinking probably not. Basically, when this car hit, the Tesla hit Mr. Hook's, Subaru, and then it took out a couple of trash cans as well. Now, Hook has apparently started a GoFundMe page to help him get a new car, and it's raised a few $1,000, but he would really like to see the guy who did it was charged. The police are saying that it is a misdemeanor hit and run, and they're offering $1,000 reward for information leading to the driver. So an update on our dumb criminal. Now, here's a very, and we're not going to put the video up because it's very disturbing. It can be disturbing, I guess. Well, I think the caption should be, "Attention Walmart shoppers," okay? A man has been arrested after trying to do inappropriate things to a woman inside a Walmart in Florida. Now, according to the Miami police, 28-year-old Brendan Harvey allegedly approached the victim inside the store from behind and pulled up her dress. Cops say that he then pushed her to the ground and ripped off her undergarments. Other shoppers saw the commotion and stepped in to remove Harvey from the victim. And a video taken during the incident shows at least 3 men pulling Harvey off the woman as Harvey tries to flail around with his arms. Many other shoppers were watching and were also intervening. There are also children in the video. One of the women that was interviewed, a shopper by the name of Kayla Harris, said she doesn't even know what to say. I'm at a loss for word. Where is the protection? It's a shame. It's a shame there's kids that come here. There's families. This man's been arrested and behind bars currently. He was going to have court later, I think tomorrow, and he was already on probation, this Mr. Harvey guy. So we'll put the video up somewhere. Maybe we'll put it up on scottreich.com so that, YouTube doesn't get offended in any way. But it just shows you, ladies and gentlemen, you have to be prepared to take care of yourself literally at any time, even when you're shopping. This woman was just minding her own business. And that's the scary thing, is it's just so random that this took place. And thank goodness for the good Samaritans that were there to help out this woman. I mean, what a scary, scary situation. And, what can you do? But what would be a day without at least our dumb criminal? Please meet Kristen Wiley. Now, she is a 49-year-old teacher from Florida, and she was pulled over by the police the other night for suspicion of drunk driving about 2 a.m. When the police walked up to the car, they also noticed that her son was in the back seat, apparently not wearing a seatbelt, curled up and crying. Police reported that Miss Wiley had red shot, watery eyes, and she reeked of an unknown alcoholic beverage. which is enough to make a good stop just about anywhere. Well, the police then asked if she had been drinking, and of course, what did Miss Wiley say? She said no. She had a 50-50 shot there of saying no, or I had a couple, because they always say a couple or a few. Well, Miss Wiley's son, apparently she's done something right. Miss Wiley's son piped up from the back seat and said, "Mom, you can't lie to the police. You did drink." Then the boy told the police that she had been drinking at a party and asked her to slow down multiple times while they were en route home. Wiley eventually agreed to a breath test where it was determined that her blood alcohol content was nearly 3 times over the legal limit. She was also charged with felony child abuse for a drunk driver that had her son in the car, in addition to a misdemeanor DUI. She's being held at the local jail in lieu of a $2,500 bond. So, Miss Wiley, it's not illegal to drink. It's not illegal to drive. It's illegal to drink and drive over the legal limit. And when you put someone else at risk, not to mention all the other people on the road, let alone your own child, well, that's where things get ugly for you. And you apparently done something right with your kid. That, you shouldn't lie to authority. But once again, we've talked about it before. There's legality and morality. And guess what? It all paid off here in this particular case. So those are some of the headlines today. But let's get to the big story of the day. And I think this broke late yesterday afternoon, but I was on an airplane and couldn't get to anything. But for those who aren't familiar with the case, obviously Lori and Chad Vallow are charged with conspiracy to commit first-degree murder and grand theft by deception in relation to the death of Tylee Ryan. And then also in the indictment, Chad Daybell is charged with conspiracy to commit first-degree murder and grand theft in relation to his wife, Tammy Daybell. All right. Now, the case has been going on forever. I mean, first it started out as basically kind of a child neglect case. Then it turned into tampering with evidence, something along those lines. Still makes me kind of wonder if the clients maybe told everything to everybody, because I think they could have gone in and said, "Hey, man, I'm pleading guilty to this witness tampering," and I think jeopardy would have attached, but that's just me. And hey, what have you got to lose, right? But they didn't do that, because why? No one ever listens to Scott. No one ever listens to Scott. And not that Scott likes to say, "I told you so," but Scott likes to cover his butt when clients ask for advice, pay good money for it. Scott says, do option A, and then they do option B, and then come back and say, "Why did you tell me to do option B?" I said, "Oh, no, my friend. Here's the letter stating I said do option A." Well, anyway, it's just something I think I've worked on over the last 27 years, because sometimes clients like to change their recollection of events. You have to be prepared. So anyway, the case goes on. They ultimately, everybody gets indicted: conspiracy to commit murder, J.J. Tylee, and also for the death of Tammy Daybell. All right, Chad and Lori, they get married in the process. I'm not really sure it's really kind of valid, whatever. And some people said, "Why do you refer to Lori Vallow as Lori Vallow?" Well, frankly, it's just easier to distinguish everybody. Lori Vallow, Chad Daybell. Okay? So for the lady that was upset that I didn't refer to her by her proper name, that's why. It's just easier. Hell, I think the court was even doing it the other day, referring to her as Miss Vallow. Anyway, so the court in Idaho's done something very weird. It's kind of been this piecemeal motions practice. And normally in a case, the judge says, "Hey, you've got your deadline to file motions within 28, 35 days. Maybe you can get a little more time if it's a complex case." And then you set motions hearings all on one day. And I get it. Things come up. You have to be able to deal with it. But normally that one day is your moment in time reserved to do everything you need to do. Right? Bottom line. Anyhow, one of the motions that was filed, and it's gone back several months, was a motion for severance. It was actually filed back in September 7th of 2021. And it's basically Mr. Pryor, on behalf of Chad Daybell, contends that the joint trial would be prejudicial, arguing that difficulty in preparing the defense and doing the necessary preparation when there is uncertainty as to whether one of the co-defendants will be present for trial creates a number of evidentiary issues. I'm not sure I really understood that argument. I get what he's trying to say, but it's a conspiracy. For the most part, it's going to come in, okay? It's a conspiracy, an agreement between two or more people to commit an illegal act. That is a conspiracy, right? Some people are like, there's no conspiracies ever. Of course there can be. An agreement between two or more people to commit an illegal act. That's all it is. But the bigger issue, I think, that was raised and basically argued, and frankly, the whole, hey, it's too difficult to prepare, I don't know what evidence is going to be coming in, it just doesn't matter because most of it's coming in. Now, there were representations made at the motions hearing by the prosecution that there will be statements, there will not be statements. Let me make that clear. There will not be statements made by Lori Vallow that are introduced against Chad Daybell. That's what they refer to as the Bruton issues. And I think we talked about that last Friday, so you could go back and watch that. I think I explained the Bruton issues pretty well. Basically, when one co-defendant is going to testify against the other, or statements are made or introduced by like the police saying, co-defendant A confessed to me, co-defendant B, nothing came in. It's prejudicial to use it against both people. As far as we know, nobody has rolled on each other in this particular case. So that, I get it. Mr. Pryor at the motion hearing tried to say, the judge, I'm prohibited from supplying any information about that. And the judge is like, well, no, you could have done it under seal. Then he asked the prosecution, he stated, and he states in his order as well, hey, you're an officer of the court. Are there going to be statements brought in? And frankly, it really doesn't matter because a motion for severance could be granted mid-trial where, the judge is like, okay, this is what you told me it was going to be. This isn't what you're telling me it's going to be. I'm going to sever out, defendant C from a particular case. I've seen that happen numerous times, usually in federal drug conspiracies where they tried to say everybody's a co-conspirator and then the evidence just doesn't come in, or there's evidence, relating to one but not to others. So it can get really tricky, which is why I prefer kind of do what Mr. Pryor did, say, hey, judge, if they have any statements whatsoever, put it in a spreadsheet, basically say which statement made by whom, what legal theory it's going to come in under, i.e. which rules of evidence, who's going to be the proffering witness, who's going to come in and say this, and have a hearing to determine if those are coming in. I'm telling you, it helps everybody. Prosecutors hate doing it, but it helps them go through and say, I want this statement. It's made in furtherance of the conspiracy. It's an admission by party opponent. Whatever comes in, under what theory it comes in. So prosecutors don't like it, but helps everybody flush out what is truly relevant. But the prosecution says, oh, we're not aware of any statements, Judge. We don't intend to do that. And then the other argument was the prosecution said, hey, Judge, judicial economy, it just makes sense to only do one trial. It's going to be much more efficient because we don't want to put the victims through two trials. I get it, but fairness, fundamental principles of fairness require two trials if that's what it takes, okay? And then the ultimate argument that the DA on, I think they failed miserably. I think they overreached, and the court called them out on it in the order, was that they said, hey, Chad Daybell has waived speedy trial, so he can wait in custody as long as it takes for Lori Vallow to be restored to competency, and then we'll have a trial. Well, the judge agreed with him on most things and said, well, all right, there's no Bruton issues because there's no statements coming in. Judicial economy makes a lot of sense. We will do that. As it relates to, it's really hard to prepare. Well, basically the judge says, deal with it, get ready. for whatever you need to do, okay? And just be prepared. It's called trial work. It's called litigation. Things change. But when you get to the big issue, all right, and this is the part that everyone was jumping around with glee. The defense lost their motion to sever. The defense lost their motion to sever. It's going to be the same evidence if they do it 1 time, 2 times, 3 times. It's all because it's a conspiracy. The same evidence is coming in. A few minor changes at best. But then, this is the bombshell. This is what the prosecution didn't really want to address. They kind of glossed over it in their argument. And the judge got it. And it really came down to Pryor's argument. He said, yes, we waive speedy trial, but the uncertainty of when that could take place is just not fair. And I can kind of tell, no disrespect, but Mr. Pryor, he knows the law. He knows the general aspect of the law, but his briefs are a little weak, okay? Don't cite a whole lot of case law or authority or really get into the crux of it. But he knows, he's been practicing law for quite a while. He knows, the gist of the law, and he gets it. And the judge basically said this. He didn't basically say it. He said it. Let me read from it. Finally, the decision to deny the motion to sever in this case shall in no way be construed as to stay this case pending the competency determination of co-defendant Lori Noreen Vallow. See, even the judge just refers to her as Vallow. Severance is a legal issue relating independently to each defendant in their conspiracy case. However, availability for trial is not determined under the same legal analysis. While it is true, as the state has urged the court to consider, that the defendant waived his speedy trial right, that waiver is not indefinite in time or scope. Notwithstanding his waiver and notwithstanding the current inability of the co-defendant to be brought to trial, due process still requires that the defendant be afforded a jury trial without unnecessary or excessive delay. Therefore, the court's December 3rd, 2021 scheduling order requiring trial to commence January 9th, 2023 remains in full force and effect. Okay? So some could say that the defense lost. I don't think they lost. Frankly, I think the prosecution lost in big time when it comes to the motion to sever. I didn't think they were necessarily going to get a severance. Pryor didn't produce anything saying that there should have been. And the bottom line is that the trial still goes forward. And if Lori Vallow's not there, guess what? Chad Daybell's trial will commence on January 9th, 2023. If Lori Vallow's there, great. But if she is not, they're starting the trial. And if and when she is ever restored to competency, which I don't think anybody knows for certain, but I'm getting the feeling that she is not going to be appearing in court anytime soon. I've said this once, I'll say it again. Based upon my experience where people have been diagnosed with delusional disorders, they don't usually come back and join us, at least not for a long, long time. So I think Pryor won on behalf of his client. He still gets a trial date. Don't go continuing the trial anymore. And guess what? You will have a single trial or single defendant trial where you get to point your fingers at both Alex Cox and Lori Vallow the entire time, and she can't point the finger back at you. You're throwing your wife under the table, so to speak, under the bus, figuratively, of course. But that's the defense that I think I would run based upon what I know. Like, ladies and gentlemen, that woman's crazy, and she fooled all those people. And Chad Daybell can sit there and say, I got fooled too. She's attractive. She was smart. She seemed competent to me. Everybody thought she was competent. I didn't know. Just weird stuff, man. She fooled me. And I don't know what she and her brother did when I wasn't there, but I certainly wouldn't, kill anybody. Jeez. Who knows? But I don't think the government won on this one, because they really wanted the trial to be stayed indefinitely as long as Lori Vallow is deemed to be incompetent. That was their big issue, because they know, I think they know, she's probably not going to be joining us for January 9th trial date. And that's what they didn't want to do. So we'll see. Who knows? Maybe it'll be a competency restoration miracle. There's been a lot of miracles going on lately. I don't know where you live, but we had like a lot of COVID miracles where suddenly no masks were required, except at the airport. Don't get that one, but it was a miracle. I was in federal court the other day. Everybody's all masked up. We're wearing our masks. Judge comes out, oh, yeah, we had a hearing. You can just take those off, right? So maybe at one point there'll be a competency restoration miracle. Lori Vallow will be deemed to be competent, and it'll just be like that. She'll be joining, him. Okay, let's take a look at some of the chats here. I do think Chad is responsible for her death. Jenny D, I respectfully disagree. I'm not sure if that's in regards to what I said or what somebody else said. My perspective, but Chad's the one that called Lori a goddess. I get it. I wonder how long it'll take to her beliefs. Yeah, she didn't fool him into killing his own wife. I understand. I'm just saying. That's the defense. Okay? Prosecution has to prove it beyond a reasonable doubt. Defense has to raise reasonable doubt. I told Mom Larry we need to drive our buses up to the trial so we can get the buses and run them all over. Well, let's not do any harm to anybody. Young Miles Limpy. Why does everyone think Chad killed Tammy specifically? Were there any clues? Well, the autopsy has been sealed, so we don't really know. But there was the incident where Alex Cox allegedly went up to the house and shot at her at some point. It would kind of make you think. And, of course, a week after, 2 weeks, I think it was, or days after. It's been so long since this case has been going on. From the time of Tammy's death, Lori and Chad run off to Hawaii, get married, all that kind of stuff. I think it was like within a couple of days. I mean, that's just weird. And the Neva Sleva? What happens if she's restored after the trial? Then she gets her own separate trial. Is Chad being tried for all of Tammy and the kids? Yes. Lori Daybell pretended Joseph's Ryan case and played the courts. Well, I mean, I've mentioned this before. I truly believe that if the professionals down there thought that Lori Vallow was faking, malingering, being mentally incompetent, they would have discovered that by now. Now, who knows? There was a report sent up just recently. They had a hearing on it. It was closed to the public, so we don't know for privacy reasons. But, hey, if she shows up back at the local county jail, she's been restored. Bottom line. If she doesn't, we can do that. And I haven't checked in a while. Can we look and see if she's on the Fremont and Madison County Jail? I think she was at Fremont, that's my recollection. Or maybe, I don't remember which one she was. But, you can usually look online on booking information at the jail. If she shows up there, so all of our, sleuths out there, if you want something to do, check the Madison and Fremont County Jail on a daily basis to see if she has been processed in. If she's processed in, she's competent. If she stays at state hospital, she's not competent. It's usually that simple. Let's see. Ashes to ashes. Yes. Commentators on Justin Loom's Facebook page are saying that Lori Vallow's status on Vine has changed from inactive pending to pending. Okay. Maybe it means she's coming back. I don't know. Harlow, hey, Scott, could you please take us for a tour of all the items on your bookshelf? We could try to do that. Maybe near the end here. Sure. We can try to do that. All right, let's get some more questions as it relates to Lynn, shouldn't we be seeing a death penalty qualified lawyer for Chad soon? I think Pryor probably fits the standards for death penalty qualified. I mean, I think their standards were you had to do at least 10 felony trials or something, preferably homicide cases. A lot of people don't get to do that if you don't really do that kind of stuff. I can tell you right now, I mean, I think our firm is the exception to the rule. We have lots of, I think we're up to, I guess just recently over the week, so six homicide cases. Some people don't do 6 homicide cases in an entire lifetime. So yeah, it's, I think he meets the qualifications, and, the reality of it is if Chad Daybell is convicted and they give him the death penalty, it'll be in litigation for appellate purposes, post-conviction matters for the next 10, 20 years. Chad will probably be an old man. If he makes it that long, he'll probably still have that same look on his face and that same T-shirt or same dress shirt with his little tie that he wears every time. So yeah. Life of Chaos. Good question. Can they have 2 separate juries for the same trial? Yes. I've never personally seen that, but I have been familiar with cases where they basically said, hey, it's going to be the same evidence, same witnesses, and you have separate juries as to each defendant. So they could, in theory, do that. The issue is going to be a race to the clock, a race to get to trial. Is she going to be restored? Is her new attorney making enough strides to be able to do it? I mean, it's kind of tough you can review the discovery, but unless and until you actually have the opportunity to sit down with your client, see what they want to do, it's kind of tough. I'm just kind of going back here to the order here where the court notes I think it was here. Defendant contends that the uncertainty resulting from co-defendant Noreen Vallow's status and current stay will have prejudicial impact on the defense trial rights. Additionally, defendant contends that the evidence of other wrongs or act by co-defendant Lori Vallow will have a negative impact on jurors should these 2 co-defendants remain. The state responds by arguing the severance pursuant to Idaho Code is not required under the circumstances of this case, and the defendant has failed to establish the existence of prejudice. Now, the burden on this particular motion was on the defense to establish prejudice. They didn't establish prejudice, but like I said, severance can be re-raised all the time. I don't know if I ever told this story. Maybe I did. Maybe it was on a Patreon show or something, but I had and this is long time ago, multiple co-defendants, 5 I do remember, 5. And it was, let's just say they were alleged to have done horrible things to a young lady, okay? And I kept raising severance. Judge, sever my guy out. Shouldn't be here. All these statements coming in against my guy. Severance. Make a long story short, what was supposed to be like a, 4-day trial, 5-day trial, it wound up taking a month, okay? Jury selection took a week. The trial took a month. Because I remember, why am I here? I can't be here. I remember I had a case in the Middle District of Pennsylvania, and I'm like, Judge, we got to get this over with. I got to be in federal court in Pennsylvania in next week. Like, you need to move things along. Anyway, long story short, every time we would have a bench conference, he'd go down the list. Anything I had to say, blah, blah, blah. I'm like, Your Honor, I move for severance. Move for severance. Your Honor, before we start the day, I'd like to move for severance on behalf of my client. At the end of the day, anything from the defense. Your Honor, I'd like to move for severance. Okay? We go to trial. We go through the trial. Jury comes back. Hung jury for everybody. So we just spent a month doing a trial for 5 co-defendants. I kept saying severance, 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 severance. And so we're there trying to then grant set a new trial date for 5, attorneys and what have you. And then the district attorney gets up and says, Your Honor, we're going to agree to Mr. Reich's motion for severance. And the judge looks at me like, Mr. Reich, you finally got your word. He goes, what's your position? I said, I object. And he looked at me like, why are you objecting? I said, Judge, I want the prosecution to have to state on the record what has changed. I said, because we just went through a 1-month trial. I kept moving for severance. They kept objecting to it. You kept denying my motion. What has changed other than now the district attorney wants to do it? I want to put on the record for appellate purposes. And the judge said, well, Your Honor, it's just we think it's more convenient to do it without Mr. Reich's client. And frankly, because I was, giving them a run for their money, I think I helped create some of the doubt for sure. Not all of it, but some of it. And so I was upset. But the judge said, well, I'm going to grant it, Mr. Reich, nothing personal. Well, nothing personal at all, Your Honor. You just keep doing the job of the prosecutor, Judge. You're gonna go places. They tried that case 3 more times, and it hung. The 4th time, they convicted 4. Guess whose client never got convicted? That's right. This guy. That's right. True story. True story. So, severance can be, the point of that story, the moral of that story is that severance can be raised at any time. You have to raise it literally on a daily basis. Anytime you have an issue, Judge, they're bringing in statements that are being admissible against only co-defendant A. It's prejudicial to my client. Move for severance. Move to strike. One limited instruction at a minimum saying, Judge, this can only be used as against this particular defendant. And maybe when the judge gets tired of reading that limiting instruction saying the evidence that you're going to hear is only going to be applicable to one defendant, not the others, the judge may get tired of doing it and say, you know what, I want a severance. Like I said, I've seen severance granted mid-trial where the judge is like, you didn't bring any, there's no conspiracy. This guy shouldn't be here, right? Kick it out. So you just never know. I wouldn't get too spun up about it. My personal opinion, we'll see. I mean, I don't know. There could be a miracle, but I don't think Lori Val's going to be there. Jen Lowe, can you look up patients at a state hospital? I don't believe so because of privacy interests. It's kind of funny. You can't call a hotel and somebody confirm whether somebody's staying there. You can't get it at a hotel. You basically have to have, prove that you're associated with somebody even at a hospital. But if jail, you can look it up online, man. When you go to jail, you have no privacy interests whatsoever. Okay, Karen clarified it. She was at the Madison County Jail. How can Chad be tried without her? I don't see a precedent, question mark. Maybe precedent? Sure. It's a conspiracy case. Just bring in the evidence. They have to establish that there's a conspiracy for the case to go forward, and then they can start introducing statements in furtherance of that conspiracy, assuming they have the right people. Jackie R., he's guilty AF. I'm not saying the guy's innocent. We'll give him the presumption of innocence because, well, that's what we do here. And so, yeah, we'll have to wait and see. But, I've had cases where people have been charged with conspiracy, and I was the only client. My client was the only one there. Sometimes the co-conspirators show up and testify against you, right? and say, oh, yeah, this is what we did. This is what we meant. Okay. And then you cross-examine them on being liar, liar, pants on fire, right? And you'd be surprised. Most like snitches in drug cases, I've walked, that I can think of off the top of my head, 2 very significant clients in very significant large amounts of drug conspiracies where the co-defendants are co-conspirators, and they come and they testify because, that's what they're doing. They're protecting themselves. I get it. If that was my client, maybe I'd be telling them the exact same thing. But a snitch that's going to jail, the last thing they want to do is be known as a total snitch jacket, right? So when they get on the stand, they want to help the defense. They're like, hey, man, nothing personal. I'm just trying to do what's good for me, right? And at the end of cross-examination, they will put, the client on the grassy knoll in Dallas in 1963. They'll say anything to get their benefit of the bargain from the prosecutor, to say what they have to say. But then on cross-examination, they try to help you. Yeah, I don't really recall that. Yeah, no. Sir, you're not a very truthful person, are you? And some of them say, no, I'm not. In fact, we shouldn't trust you. This jury over here shouldn't trust you in any way, should they? Well, no, not really. Or if they say, like I had this one guy cross-examined, it was beauty. Beautiful. At the last minute, the government turns over all this. The guy is co-defendant, a multi-drug case. He's in federal court. Immigration puts a hold on him, and they deport the guy by mistake. Well, he gets deported, and he gets caught coming across the border like within 3 days and gets arrested and what have you. So they turn over all this stuff where this guy had been deported like 8 times. And I'm like, you're not a very truthful person, are you? He goes, well, no, I think I am really a good, truthful person. I'm like, oh, really? You remember signing all this paperwork when, you got deported on the X date? Well, yeah. Well, it says you promise not to show up unless the United States attorney lets you come in, blah, blah, blah. All these things you're supposed to do. You didn't do that, right? So you basically just say whatever you want to say if that's what gets you out of the situation you're in, right? Well, no. Okay, let's talk about the other incident. You signed all these things saying, I'm going to promise not to show up back in the United States unless I get permission from the Attorney General. I'm not going to do this. And if I do come back, I'm going to do this and blah, blah, blah. And you never did any of those things, right? So once again, you sign or say anything to get out of a particular situation, right? And after about the second or third time, he starts getting it. He's been deported like 8 times. Like, fine, let's just keep going through it 8 times, right? Suddenly, by the end of that, even he believes he is not a truthful person whatsoever. And the jury certainly will believe that too, because juries don't like people that lie on the stand. They will give you the presumption of innocence, okay? They will follow the judge's instruction to hold the government to their burden of proof, make sure they prove each and every element of the offense. But if you get up there and you lie, the jury will punish your client, okay? Look at Jussie Smollett, the jury, very diverse ethnic jury. He got up there and lied because they found him guilty. They didn't believe his story. So, yeah. Anyway, we'll leave it at that. Sarah, great stream, law student from New Zealand. Welcome. Always watch your videos. Well, thank you very, very much. My perspective thinks that Lori will be deemed competent. Perhaps she may. Competency moves in mysterious ways. You can be incompetent to competent. It just really depends. Lori took many steps to hide whereabouts of the children after they were gone. That points to guilt. I cannot necessarily disagree with you on that. If she was a goddess and had power to take them out for whatever reason, she would just let that be known and let the chips fall where they may. But she's not going to do that. And you have to be able to assist in your defense, right? You have to be able to assist in your defense. It's one of the things for competency. I think Scott's next emoji should be true story. I know, because you can't make this stuff up, right? True net crime, I think so too. Let's see here. Scott, please give us give us a life sentence for Chad Daybell. He may just get it. He may get the death penalty for all I know. Oh. Samantha McDowell, respect Scott, 1.6. Oh, I guess we have 1,600 people watching right now. That's great. Ray, the cellmates testify so they get a free ride out of prison just to get out of jail for a while. That's true. Snitches, jailhouse snitches, the worst. Don't trust them. Oh, is there? It's not showing up on my thing. Okay, let's see if we can find the super chat because... Sure, what's the question on the super chat? Sorry, it's not showing up on my...
Larry Woodcock believe that Lori's faking her incompetency. You believe she could possibly get away with that?
Yeah, you can get away with faking competency for a little bit, maybe enough to get you to the state hospital even. But there are a battery of tests. We did a video on this that explains there's a battery of tests where they can actually tell if you are malingering. And so you may be able to get away with it for a while, and I appreciate the Woodcocks, their frustration with this. It's being delayed. You know, the old thing, justice delayed is justice denied. I get that. And they're just looking out for their grandchildren. I understand. But I don't think that she's been down there, 6 months, I think? 6 months. If they thought that she was faking, they would let us know. She would have been back in 30 days. So we'll see. We'll see. Thank you for the super chat. Pretty lies and alibis, fashionably late to the party. As always, I guess, right? Any good questions there? Pretty lies and alibis, who are great source of information, just let you know. They always seem to have information before everybody else. Right, Julie? They're good. Yeah.
I go to them for the breaking news.
Yeah. So, Pretty Lies and Alibis. Julie highly recommends them. They always seem to have their finger on the pulse of what's going on. We'll see. Let's see what other questions we got here. Coffee on my shirt. I seriously want this to be televised. Me too. Otherwise, that means we're going to have to go to Idaho the first week in January. That could be really cold. Scott doesn't like the cold. I mean, Scott will go in the cold if he has to, but he will dress appropriately. Veronica, every time I hear Jesse's name, my blood boils. Yeah, that case just, if he had just, I don't know, we did a video. The perpetrator in the Jussie Smollett hate crime case was sentenced today. And I don't think a lot of people got that, but because it was him, right? But, the guy lied. And, there's so much stuff out there where you just, why are people so intellectually dishonest? They just pick a side, usually based upon politics, and they pick sides. And my side, right or wrong, this is it. They're going to... And it's so frustrating because as an attorney, you can't do that. Your duty is to the client, not to your agenda, not to what your political beliefs are. It's to the client. And it just frustrates me how, particularly in politics, how much, what lack of critical thinking there actually is. It's just... Let's see here. Oh, Jenny X. Explain, assist in your defense. Good question. So when somebody, basically if the issue of competency is raised, obviously you need to be able to understand the proceedings, right? What are the roles of the player? What are the charges? Do you understand what you're charged with? Possible consequences, things like that. It's a pretty low threshold to raise the issue of competency. But one of the other factors is that you have to be able to assist in your defense, right? So when the attorney goes out and talks to you and says, hey, let's talk about, let's say, your homicide case. and all you want to talk about is everything but that particular incident, well, you can't really help your attorney in that regard. And it's not just, I don't like talking about it. You do whatever you want. It's like they have just no interest. They don't think it matters. They don't think, whatever. Or they refuse to cooperate with the attorney. That didn't seem to be the problem in the case with Mr. Means. He was all about helping out Lori Vallow. But you need to be able to assist your attorney in the defense and say, yeah, okay, I was there. This happened, this something along those lines to help prevent a defense. But with clients that have been diagnosed with delusional, and it took me a couple of clients to get there where I can spot this one, okay? But like you talk to a client, you're like, hey, great, you're charged with this count. Let me explain it to you. And the client will be like, oh, yeah, you're wrong. Okay, tell me why I'm wrong. And they start going off on, this is, under the Constitution, this. And you're like, no, that's completely incorrect. Well, no, and the client keeps telling you you're wrong. And I've been corrected by clients, but when they're just making stuff up or they think a case from New York City or New York State, from 1962 somehow affects the law where you practice law, you're like, yeah, no, that's not even persuasive authority. So thank you. But you're wrong. And they kind of pick and choose things that they like and ignore other things. Like I said, you have to start thinking, is this client totally delusional? And normally that is, in fact, the case. I've had situations where people that have been found to be incompetent to stand trial where you literally would be on the phone with them for 2.5 hours. And you just think to yourself, that's 2.5 hours of my life that I will never get back. And I'm not exactly sure what the hell happened, but we talked about everything other than the case. And you think, okay, well, maybe he's just being difficult. He or she's being difficult. Maybe they're just passionate about it. But then you start digging a little deeper, and then it all comes back to, well, it all started to the great conspiracy against me when they did this and they did that. And so it just, it's hard to explain if you haven't seen it. But when people are truly delusional, I mean, you can't fix it, and if it's the type of person that, thinks somebody's, in their house. I mean, I've seen cases where people there's somebody in my house. Okay, well, I can't really help you, but here's a private investigator. I've had private investigators literally sleep in homes, right? To see if somebody's coming in. There's nothing there. They were there all night. And they're like, oh, well, they must have known we were coming and they didn't come over that night. Wait and see. Uh-oh. Oh, okay. Frank told me we lost connection there for a second. Hopefully, we'll see.
For a couple seconds.
All right, well, I'm glad we're back. All right. Cacao. I think that's it. Or CACU. I'm not sure how that is. Cacao was from, what was it? Portlandia or something, right? Was it? Cacao. How often is competency reassessed? Usually when there's a court involved, 30 to 90 days, depending on statutes in the particular court. That's why we know several weeks ago there was a report sent back to the court. And obviously we don't get to see it because of privacy issues relating to medical treatment laws. But that's the way it is. So like I said, we'll have to wait and see if she somehow shows up. When she, referring to Lori Vallow, if she shows up back in court, she must be competent again. But just because you're competent for a little while doesn't mean that you can't go back out of competency as well. Caroline, psychopaths are highly intelligent, and I believe Lori is one of them. She's pulling the wool over everyone's eyes. Caroline, she very well may be, but there's a lot of professionals that have seen it all, so to speak. And yeah, bottom line, I really think that if she was truly faking it, they would have called her on it by now. But hey, I'm not a doctor. Don't play one on TV. Not a psychologist, psychiatrist, anything like that. But yeah, it could take a while. Rebecca says, I knew a woman who believed that a guy she was dating he had written all of the songs on the radio about her. Very creepy. She would just say, "See, you wrote that." Yeah. And that's kind of it. People just believe weird things. I mean, I've seen it. You're just like, okay, like all those rocks out there, those aren't rocks. Those are moon rocks. Oh, okay. Because I thought the only moon rocks came from the moon when the astronauts landed there. And then they're, of course, well, did they really go there? And these are all moon rocks. I'm saying they're moon rocks. All the experts don't know. They just don't understand. Okay, got it. Let's see here. He hasn't even been in the office long enough to have that effect, but I disagree. Sure. Let's see here. Natalie, does being married provide Chad and Lori any benefits with regard to testifying against each other? Natalie, the question that the term you're referring to is marital privilege. There's various privileges, right? You have your doctor, patient privilege, your priest, penitent privilege, spousal privilege. You're not supposed to be called as a witness to testify as to something that you learned during pillow talk. However, like most states, there's usually exceptions to those rules, particularly when it relates to child abuse, domestic disputes, maybe some violent crimes, but it usually falls under domestic child abuse, right? We have basically child abuse cases. So I don't see any benefit to that, and it would only apply when you are actually married. It would seem as though all of these alleged crimes took place before Lori and Chad were married, so the privilege wouldn't apply. So it has to be when you're actually married. So, yeah. Let's see here. Can they be waiting to transfer her back to custody until after her arraignment so that there is no regression due to stress? Archibald had her on the call during the last hearing. Usually you had to be present. If there was an arraignment, that's something that should be done in public. Obviously, we don't know what the hearing was about. We'll just have to wait and see. But if she's brought back, just because she's there, doesn't mean she's competent. Obviously, she's been present for the last couple of hearings. So, who knows? Maybe it's part of some therapy or something that they're trying to do. Shelley B., I want to know how she passes the one Charles had done on her in the middle of her crisis. Now that it's all done, she can't pass it. She's good at playing the part. You never know. I've seen people come back. Different people can disagree. You go to a hospital, man, they're busy. Oh, you're having a dispute about child custody. He's saying you're crazy. Okay, you seem to be fine with me. You can fake it. Remember, when this case started, although I'm not sure Means would have known exactly what to look for when it came to competency, but it was right about the same time that Archibald came on the case. And so I think that's a little interesting as well. Suzanne Magiola Padraig. I'm a non-practicing neuropsychologist. I've interned in UK in a high-security prison psych ward. I think they'll get her back to competency, but it'll take 6 to 8 months tinkering with meds. Yeah, Suzanne, I cannot disagree with you. That's my experience. It's going to take some time to actually get her restored to competency if they can. It just really depends if they can get her back. So, wow, can you look at that time? Already an hour. We go for an hour on our show here. We've got all these people here. Well, maybe they'd like to continue the conversation if they head over to our Patreon show that will start here in a bit. Can't believe it goes by so fast. Sandy, can Arizona force extradition of Lori while she's in the hospital? Unlikely. she has a case pending in Idaho. That case will be resolved first. Then she'll go to Arizona, depending on what the outcome is here in Idaho. Would she go there? Frankly, Arizona doesn't want her back until she is deemed competent. Okay. Otherwise, Arizona people from Arizona will be spending all of these their money on keeping her housed and restoring her to competency until then. They don't want anything to do with her until she's restored to competency, if at all. What meds can possibly help a delusional order? That was only the situation that I was familiar with or seen several times was if they thought somebody was delusional and they were really like, okay, we need to get you out of here, is a drug called Halidol. It just kind of makes you very submissive. That's just my personal experience. Haven't seen it. Like I said, I'm not a doctor. I'm just telling you. But people don't like taking it. It makes them feel really out of it, really groggy from what I know, my limited involvement with that. So, yeah. We'll have to wait and see. P. Willie. Lori love bombed Mark Means. She's very practiced at manipulating people. Melissa D. If they get her back to competency, can her defense use that as a way to get her off due to insanity? Well, somebody will say, they always remind me, they don't have the not guilty by reason of insanity in Idaho. Okay, I get it. But if you can't form the requisite mental intent, i.e., knowing after deliberation to take the life of a human other than yourself, because you're crazy, guess what you get, right? Not guilty. So, let's see. I don't think she's coming back, especially if she's woken up to all her lies and the fact she killed her entire family. Yeah. Well, yeah, and really, and even if she did come back and she figures out what she's done, allegedly, then how reliable is what she's been told, what she said? Does she really remember it? You just really have to wonder. So, all right. I want to thank everybody for joining us this evening. I think we hit everything other than we didn't pitch anything to pay some bills around here because, we went so long. But you know who the people, we have CrimeTalk Prep, we got CrimeTalk Search. Don't forget to go Baked in Colorado, support all of our sponsors. And that one has really gone off great. I mean, these little CBD things, I'm telling you, if you've got an animal, that dog that maybe has a little anxiety, I don't know, I can think of one, Miss Winnie the Bulldog. Yeah. Chills her out, calms her down, takes away that anxiety. It's good stuff. Go to Baked in Colorado. You're going to love it. Your dog's going to love it. So, all right. I want to thank everybody for watching. Thanks again. Subscribe, like, leave us a comment if you haven't done so already. And if you haven't done so already, join our Patreon. It doesn't cost much. And then you'll get the super secret link that Frank will send to you or you have access to. And when we do our Patreon show, well, we get to talk to you because there's a call-in number. You can call in. We do the Magic 8 Ball, and we can kind of continue the conversation. There's a lot less people, poo-poo pondu. Miss Winnie is mentally incompetent. No. However, she gets these crazy eyes. I got a picture of it. She's got these eyes all bugged out when she gets so excited. She gets crazy. Cats and dogs, yes. Cats and dogs. So, do they work for humans with anxiety? Just kidding. These treats from Baked in Colorado are not for human consumption. Who's Frank? Can we trust him? Yes, we can trust Frank. Yes, you can trust Frank. He's the one that does all the technical stuff. He's the one that does it all. You can trust him. Does it work for dogs and dog finding PTSD? I would say yes. Give it a shot. Go to bakedincolorado.com, hit the links, buy the product. Boom, it'll get out to you the next day. Oh, good question. I think Lori may have been diagnosed with malingering. Might be there was more than one doctor involved. Got the feeling she's all better now. Well, we'll have to wait and see, Candace. We'll see. But yes, in those competency evaluations, it's not just one doctor. It's usually a team of people, and they monitor people every time, all the time, 24/7, 365, to make sure that they get monitored. And if they're faking, they find it out. All right, let's do this. Thanks for watching. We'll see you next time, and we'll see all of our Patreons over there in just a few minutes. Have a wonderful night. We'll see you next time on Crime Talk.